Welcome back to the courtroom, where today's hearing takes a surprising turn. Two defendants, two very different stories, but both fighting to hold on to their freedom. First up, we've got Larzelle Washington, a man trying to prove he deserves a second chance. And later, Montel Gatlin, who's about to clash with his own public defender right in front of the judge. Stay tuned, because what starts as a routine docket call quickly escalates into a tense back and forth full of raw emotion, legal strategy, and some serious reality checks from the bench.
His interview date is set for tomorrow.
Pardon?
His interview date is set for tomorrow.
So he's going to be interviewed
He's
tomorrow.
going to be interviewed tomorrow.
All right. So will they get an answer within a week?
I assume he'll get an answer really quick.
Okay. So I'll adjourn it out one more week to the 29th then.
Period.
June 29th, 2025, 9 a.m. Bond continued.
Thank you, Ron.
Thank you.
Excuse me. I would like to waive my circuit court. Thank you.
You want to waive your preliminary examination?
That's right.
And
Have you talked to your attorney about that?
Matter if I could approach with counsel.
Yes. Washington, you want to waive your preliminary examination. Your counsel's asking, or your counsel's asking that I adjourn the probable cause conference. Certainly you have the right to waive it. But usually people do that in consulting with their attorney. Okay. Now, just listen closely to me. My understanding is that there is the possibility of working this thing out in a way where there may not be a felony for you.
What?
Okay.
Pardon me?
Did you hear me or no?
No, I didn't.
That there may not be a felony.
I understand.
Okay. So that may not happen if you waive. Okay.
Right.
So here's what I'm going to do. I'm not saying no to what your request is. Okay. What I'm going to do is I'm going to put it over a week, let that process happen. If it doesn't work out or whatever happens, then we can do the waiver next week.
Right.
Fair enough?
I'm asking for a PR. No, we just waive it. One of them.
Your Honor, he's asking for a PR. I mean, I don't know if the court would allow him to get the interview conducted tomorrow.
Once I get an answer from hang on a second, Mr. Washington, you got to listen to me now.
Yes, sir.
Okay. So once I get an answer from that, I'll consider release on a PR. Okay. I'm not saying that I will, but once he does the interview and I get some information from that, then I'll consider doing something.
With all due
Okay?
respect,
But-
Your Honor, I was supposed to had this business taken care of with this young
Is
man.
what?
Would you explain to him I was supposed to had this taken care of? Please send me.
No, he's explained that to me.
Okay.
I understand that.
Well,
It's not.
I just rather let it play the role, because I'm not gonna keep coming in here every week going through this. I'm saying $174, good Lord. Y'all letting people out with worse things than that. You know, it's been a month. Forgive me. I was homeless. I missed court. My father's in the hospital. I'm a working man. If you check my check record, my unruled ground record, I don't go to jail.
Mr. Washington, I usually don't adjourn a week out. I usually go in 2-week intervals.
I know
I'm trying to get you before the court as quickly as I possibly
right,
can.
but I've been back,
Yeah.
sir, with all due respect, a month. You know, I'd be a fool not to show back up in court in front of Judge Simpson anyway. You know, I'd be a damn fool if you let me go not to show back up. But
That's probably accurate.
right,
So
you know, with all due respect,
no,
right, but
that was a heap of respect.
right, I'm just saying,
I'm good.
you know, my father is ill right now.
Mr. Washington, okay. I know you may want me to do it a different way, but you also know me well enough to know
Well, I
I'm
don't
gonna do it my way.
well,
I'm gonna hear everybody out, and this is the way I'm gonna do it. So I'll see you next week. If at that point the stuff that's supposed to happen doesn't happen, then I'm going to deal with that. I'll let you waive. I'll let you do whatever you need to do. But I don't want you in a circumstance where you might be hurting yourself. If something worked out that's going to be beneficial for you, then let's get it worked out and let's get this thing moving. All right. Thank you. His bond will continue.
Thank you, Your Honor.
Next case on the docket.
Court calls the case people versus Montel Gatlin. Shaquila's back here all. She's like, why you call me out like that? The prosecutor say something.
No. Sorry, Jennifer W. Assistant Public Defender Chelsea Vergils with and on behalf of Montel Gatlin. Please state your name.
My name is Montel Gatlin.
Thank you. What are we doing?
Your Honor, we are asking to set the preliminary exam in both of these cases. We do not have discovery in one case. I informed my client of that. He does not wish to waive the 21-day timeline in these cases. He asks to set preliminary exam regardless of knowing we don't have discovery on one case.
Which, yeah,
I mean, may I speak?
if you want.
I don't want her to represent me
Okay, so you don't get that choice necessarily, but why?
because just conflict, like we had a back and forth back there in the back room. Like, I don't think she has my best interest.
Really?
Yes.
Why? Because she wouldn't do what you
Huh?
want? Because why do you say that? Because I've never known Ms. Vergils not to have her client's best interest at heart. Ever.
By the things she said, this
A lot of things that she said you may have disagreed with, right?
really all things. she
Okay,
said.
all she said. Sometimes that's a lawyer's job. Sometimes they have to give their client the hard facts of what's going on. And they have to do that they have to give them their legal interpretation of what's going on, which may not suit with what you want to happen in the world. But they just give you a steady dose of reality. So if you disagree with her legal analysis, then
This is where things take a sharp turn. Defendant Montel Gatlin tells the judge he doesn't want his own public defender representing him, claiming she doesn't have his best interests at heart. Now, here's the twist. In court, defendants don't get to simply fire a court-appointed lawyer unless there's a serious conflict of interest or misconduct. The judge's response, "Show me your law degree," might sound harsh, but it's a dose of reality. Gatlin's frustration highlights a common tension: clients wanting control versus attorneys following the law. What do you think? Was the judge too blunt, or did Gatlin need that wake-up call?
fine, but show me your law degree.
No, I'm disagreeing with her legal advice.
Okay, and you're doing that with your legal degree that you have, right?
No, she was.
Yeah, that's what I thought.
No, I don't have a legal degree, but
I
she
know.
was trying to get me to waive things, and like I was telling her, it would kind of waive my rights to 180 days into trial, right?
She
And-
just got before me. Did you even listen to what she said? She has indicated that you don't want to waive any statutory period. So she listened to what you said. She told me that, and I was going to set these for exam. Anything else?
Yeah, I don't want her in my case.
Well, she's on your case.
Your Honor, I would ask to also address bond if possible.
Yes, you may. Hang on a second. Let me set the exams in these cases. And which case don't you have discovery on that he's trying to set it before you guys get a chance to even look at it? That makes so much sense, but go
We're
ahead.
using media discovery on 25 FB 1090.
On 1090?
Yes, Your Honor.
Discovery on that one is not complete. I'm going to note that. Do people have their witnesses available on the 3rd? Pardon? All right. Preliminary examination in these matters will be set June 3rd, 2025. 9 a.m. That's before me. There's both come before me. They're in person. That's the bond.
Your Honor, we are asking the court to consider lowering the bond on case 25 FD 1142. Currently, it's set at $50,000. He's asking you to lower it to the same amount as his other case, 1,010%. Mr. Gatlin is an Ypsilanti resident. He is employed as a plumber. He at least was before he was in custody and plans to go back to that work. He's involved with his church. He plans to abide by his bond conditions. At this time, he's been in custody for 11 days now, and he is being held until May 29th on a case with Judge Washington. His sentencing is May 29th on that case. So he hopes that the bond will change at that time and that he'll be able to be released. So we're asking you to lower to something he'll be able to pay
So he's being held on a case before Judge Washington now.
until May 29th,
What's the proceeding on May 29th? Do we know?
sentencing.
Sentencing. What kind of case is that? Do we know?
I don't know, Your Honor.
All right. Response from the people?
Your Honor, we've asked the bond to stay the same. We think it's appropriate. He does have multiple pending cases at the same time. The reason into 90 is a stolen case.
So, to wrap this up, Judge Simpson handled two very different cases with the same mix of patience and precision. For Larzelle Washington, he offered a lifeline. One more week to prove he's serious about recovery and redemption. And for Montel Gatlin, the message was clear. Courtroom decisions follow the law, not personal opinion. When the prosecution raised concerns about child abuse and flight risk, the judge held firm. No bond reduction this time. This hearing reminds us how every decision in court carries weight. Legal, emotional, and personal. If you found this case as fascinating as we did, make sure to like, share, and subscribe for more intense courtroom moments and breakdowns just like this one. And tell us in the comments, which defendant do you think deserved a second chance?